As we enter the home stretch of the Public Order Emergency Commission's inquiry into the federal government's invocation of the Emergencies Act, I want to ask the question of what happens next? What happens after the commission finishes its inquiry? Toward the end of my video last week, I emphasized that the commission itself is not a court and therefore isn't able to issue legally binding findings or declarations regarding whether the federal government was justified in invoking the Emergencies Act earlier this year to put an end to the occupation of downtown Ottawa by the Freedom Convoy. Once the commission has finished its work, it will prepare a report, and this report will go to both houses of Parliament, but neither house is going to be required to vote on the report. The findings of the commission in this regard are primarily political, but this doesn't mean that these findings are unimportant, since they are going to provide voters with an important basis on which to assess whether the government was justified when it invoked the Emergencies Act. Now, that being said, although the work of the Public Order Emergency Commission itself is not legally binding, there are several parties that are bringing the government before the federal court to argue that the invocation of the Emergencies Act was legally invalid. And in general, when we're dealing with the Emergencies Act, and we're dealing specifically with judicial review of the Emergencies Act, there are two potential bases on which the invocation of the Act can be declared to be legally invalid. The first is under an area of law that we call administrative law. And this area of law primarily deals with whether administrative state actors, so agents of the executive branch of the government, have properly exercised the authority that has been delegated to them by various statutes. Now, in this case, the federal court is going to be reviewing whether the federal cabinet's declaration of a public order emergency pursuant to the Emergencies Act was itself consistent with the terms, definitions, and standards that are laid out in the Act and in other statutes and pieces of legislation that are referenced by the Act. We talked a little bit about this in my video last week, where we asked what constitutes a public order emergency and what constitutes a threat to the security of Canada in law. The second basis on which an invocation of the Emergencies Act can be declared to be legally invalid is under constitutional law. And within this, there are two sub-bases on which the invocation of the Act can be declared to be unconstitutional. The first is under the division of legislative powers pursuant to Section 91 and 92 of the Constitution Act 1867. Now, in this particular case, it's not really being argued that the invocation of the Emergencies Act earlier this year violated the division of legislative powers. The focus is primarily on the second basis on which legislation or reliance on legislation can be declared to be unconstitutional, and that's under the Charter of Rights and Freedoms. We talked a little bit about the Charter in my first video a few weeks ago when we asked whether or not parking a truck in the middle of the street for several weeks at a time was protected by the Charter, and so we see here that this is one section and protection in the Charter that is going to be argued by some of the parties that have brought the federal government to court, specifically Section 2 of the Charter and its guarantee of freedom of expression, freedom of peaceful assembly, and freedom of association. The other sections that have been argued to be unjustifiably limited by the invocation of the Act include Section 7, because the regulations that were passed pursuant to the declaration of a public order emergency imposed fairly hefty fines and potential jail time on individuals who didn't comply with orders issued pursuant to the Act. And of course, Section 8, which guarantees against unreasonable search and seizure. And this is with regard to orders that were issued pursuant to the declaration of a public order emergency that financial institutions freeze the assets of those who have been listed as designated persons. Now, as we talked about in my first video a few weeks ago, whether or not the limitations that have been placed on these charter entitlements are going to be demonstrably justified in a free and democratic society is a separate question. The bar is going to be set probably fairly high in some ways for the government in this case, though courts tend to be fairly deferential to the government. These are extraordinary exercises of emergency powers, and so the government is going to have to make a compelling case that it was justified under the Charter and under Section 1 to place limitations on these entitlements. So these questions are now being brought before the federal court. Depending on what the federal court rules, it's quite possible that that ruling will be appealed, potentially all the way up to the Supreme Court of Canada. So it may be a few years yet before we know, from a legal perspective at least, whether or not the invocation of the Emergencies Act was justified.